Hey guys, this is John Ween, attorney and senior legal instructor with Blue to Gold Law Enforcement Training, coming to you today with another roadside chat. Now, today's question deals with weapons and vehicles. And basically, the scenario is this: you stop a vehicle, lawful reason, while the primary officer is contacting the driver. You, as the backup officer or the cover officer, you walk up and you're making contact with the passenger. You ask the passenger about any weapons, and she discloses that, yep, she's got a knife in her purse. She reaches into the purse and hands you the knife, right? You ask her, hey, can I check the rest of the purse for weapons? You have her step out of the vehicle, you frisk her, she doesn't have any other weapons on her. You ask her, hey, can I check the purse? And she is adamant, no, right? She clutches the purse against her, holds it tight against her, and says, no, you absolutely can't. Okay. And so the question is can you frisk that bag for weapons? And the answer is absolutely, right? The courts have routinely held that the presence of one weapon gives you probable cause to believe there are other weapons inside the vehicle, that fair probability that there will be additional items in that area. Okay. Now, the question is, additionally, how do I go about doing that, right? Well, your case on point is Michigan versus Long. And basically what we talk about is where we say you have reasonable suspicion to believe that there's a weapon inside of a vehicle. You can perform a protective sweep, frisk of that area, that lunge or grab area, that internal access area, right? Now, Michigan versus Long, the officer actually went so far as to open the center console and remove a baggie of drugs inside there. And so following that rationale, can we check containers as well? The answer is yes. What we want to do is we want to be minimally invasive as much as possible. We want to limit that level of intrusion. And so engage in what we call peeling the onion, right? Get that purse, get that container, frisk it to see if you can determine if there's any weapons inside there. If during that you feel something that is immediately apparent without manipulation as contraband or fruits or instrumentalities of a crime or a weapon, you can remove that item from the container. Now, if you frisk that purse and you legitimately cannot tell if it contains a weapon or not, then you can make a limited intrusion, right? Minimally, again, we want to peel that onion and go layer by layer to reduce the level of intrusion as much as possible to determine whether or not there is a weapon inside that area. Okay. Now, the officer asked, but I know, right? I know Terry v. Ohio, it talks about armed and dangerous, right? And that's always good to articulate not just armed, but also dangerous. Now, classically, the courts have held that if you are detaining someone based on reasonable suspicion, that they are going to or are currently committing a crime that's suspicious, the specific articulable facts more than a inchoate and unparticularized hunch, then you have the dangerous element met, right? And so if you can also articulate armed, well, then you can frisk them. But what about on a traffic stop? Well, I will tell you primarily the Ninth Circuit has said, yes, anytime that you contact someone, anytime you detain them, the dangerous prong is already met, right? And so articulate armed, and you've got dangerous as well. Consensual encounter? Absolutely not, right? Consensual encounter, you're going to articulate both armed and dangerous. State versus Serna out of Arizona is a great example of this. But even in subsequent cases, right? State versus Serna says where you are contacting somebody, a consensual encounter, and you believe that they're armed, it's not enough just to articulate armed to justify a frisk. You have to also articulate dangerous. A subsequent case, Gastelum versus Hegyi out of Arizona, distinguished the consensual encounter from the passenger in an automobile. And that subsequent court said that a passenger in an automobile, it's different than a consensual encounter. Why? Because they are already seized. And so if you can articulate armed for a passenger in an automobile, then the dangerous prong is pretty much going to be met as well. Obviously, articulate, armed and dangerous whenever possible. And if you are going to be pulling people out of cars and taking weapons off of them, you should be able to articulate dangerous, right? I mean, the Second Amendment, God bless America. The reason why other countries will never successfully invade our country is because as the famous quote from World War II established, there's going to be a rifle behind every blade of grass, right? And so respect people's Second Amendment rights. If you're going to be pulling people out of cars and pulling weapons off of them, you should be able to articulate armed and dangerous. Again, the United States Supreme Court and many lower courts have routinely recognized the inherent dangerousness associated with traffic stops. Arizona versus Johnson, Pennsylvania versus Mimms, Maryland versus Wilson, and so on and so forth. So Hopefully that helps, guys. Hopefully that gives you some direction. I'm going to throw the links to those cases in the comments below. If you guys do have any other questions, please do not hesitate to reach out to us. We always want to be a valuable resource whenever possible, answering your questions and helping you to make sure that you get it right every time. Please go to our website, sign up for our free webinars, subscribe to our social media, and I hope to see you at a live in-person training soon. Until next time, I'm John Ween with Blue to Gold Law Enforcement Training. Be safe out there and make good case law.